My name is Varoujan Avedikian, and as I like to call myself, I'm a former central banker, very dear to this organization. Right now, I'm practicing financial law in Armenia, and I'm the managing partner of TK & Partners, a local law firm that is who is the author of this legal opinion that I'll present today. Let's see how this works. Okay. Can I? Yeah. Okay. All right. So first, I'm extremely humbled to be here because this is a reform that has started a couple of years ago, as Garagin has mentioned. And for this, I would like to thank the three organizations for leading this effort. First, our host, the Central Bank of Armenia, for always being keen on the reforms for extending the local repo markets and for deepening the financial transactions with foreign counterparts. To ADB for always being supportive of the financial reforms of the government of Armenia and the central bank, and for the International Capital Market Association for believing in this project and for assisting us tremendously during these past few months and making this happen. So I would really like to acknowledge all of their leading roles that enabled us to publish this report. I'll start off from talking about the key legislative milestones, which I believe are extremely important for repo markets in Armenia and for repo transactions. Before 2016, financial institutions were, even right after the Armenians' independence, they were always entering into repo transactions. So these were not new transactions to the Armenian financial system. But in 2016, a couple of legislative amendments had been introduced into the civil code that enabled internationally recognized agreements, financial agreements, to be implemented in Armenia. This was an important reform back in 2016, which acknowledged and introduced the international financial transactions into Armenian legislation. The second important legislative milestone was central bank's, our host's, resolution back in 2017 that listed the International Capital Markets Association's Global Master Repurchase Agreements within the list of internationally recognized agreements, thereby saying that the central bank, as the financial regulator in this country, recognizes this agreement as an internationally known agreement. Thus, in Armenia, this agreement can be entered into or executed both by Armenian residents between themselves and Armenian residents and foreign financial institutions. The third important legislative milestone was only 2 years ago, where my colleagues who are with us today, Alisa and Elias, some others as well, introduced important changes into the civil code again, whereby the civil code, as many of you may know, that Armenia follows the civil, is a civil law country and follows the civil code as the primary source of law for transactions, including financial transactions. So they introduced the notion of repo agreements within the civil code. And I'll talk about why this was important in a minute. So these were the basic and main legislative milestones that we had so far. When they introduced, when the definition or when the repo agreements were introduced into the Armenian civil, into Armenian law, a a definition was given, which is here. I will not repeat the definition, but it's here in front of you in this presentation. It comes from the civil code, which basically clarified what is a repo agreement, why is it important, who are the parties, how can they enter into a repo transactions. Of course, Armenian financial institutions were entering into local repo agreements, but I have to admit that in some cases, those agreements were far away from being called a repo transactions. Sometimes financial institutions got creative and maybe used transactions under the heading of a repo transactions, but those I think sometimes were far away from a typical repo transaction. The central bank's resolution of 2017 introduced an important novelty into Armenian law back in 2017, which was not heard of even, and this is the only case, I believe, where Armenian residents, two Armenian citizens or two Armenian companies, they can enter into a repo transactions under English law. For some, it may sound very usual, but for Armenian lawyers, this may sound very strange because Armenian citizens or Armenian nationals or Armenian companies, Armenian resident companies, are generally expected to enter into transactions between themselves only under Armenian law. And international financial transactions which are stipulated under the central bank's approved list, including the GMRA repo agreements, are one of the few transactions whereby two Armenian companies, two Armenian financial institutions can enter into a repo transaction under English law and submit any dispute that they may have to English courts. So this is a novelty under Armenian law, which was not around until 2017. And even after 2017, no other agreements, I believe, can be entered into under foreign law in Armenia.
Can I have a question?
Of course. Or maybe, do you want to leave it to the, because we're going to have a Q&A session.
It's very relevant. My question is, English courts or Armenian courts can take English law and make their judgment?
Both.
Okay.
Both. So the jurisdiction can be under English law. So the governing law can be English law, and English courts can hear any disputes between two Armenian companies if the transaction is a repo transaction. For some reason I can, yeah, okay. All right. So I would like to share the good news with you, ladies and gentlemen, this afternoon. And the good news is that, as Lisa helpfully mentioned, the legal opinion will be published today on ICMA's website. But right here, I will give a couple of points which highlight the main findings of the legal opinion. First of all, the GMRA, according to the legal opinion, will be valid, legal, binding, and enforceable under the laws of Armenia and will take effect in accordance with its terms. The second conclusion, according to the legal opinion that will be published today, the GMRA netting provisions would be enforceable in all insolvency proceedings, including non-liquidation insolvency. And the third, a court in Armenia would uphold the choice of English law and the submission by the parties to English courts. So these three main messages I wanted to share with you this afternoon, which stem from the legal opinion's conclusions. As Lisa mentioned, the legal opinion will not only be shared to ICMA members, because under ICMA regulations, legal opinions, country legal opinions are shared only to ICMA members. So I'll also like to use this opportunity to encourage financial institutions present here or who have joined this webinar to become ICMA members if they're not. The central bank, I believe, is the only institution, right? If I'm not mistaken, that is a member.
From Armenia, we are.
From Armenia, the Central Bank of Armenia is the only institution that is member to ICMA. Usually, ICMA shares legal opinions only with its members, but we have had an understanding between the Central Bank, ICMA, and our law firm that we will allow the Central Bank to share the legal opinion with Armenian financial institutions. So Armenian financial institutions will have access to the legal opinion as a sort of special gesture, because usually it's legal opinions are not, as I understand. So you will have access. The central bank will share it with you in due course. So now some of you may think, why is this important for Armenia? Why is this legal opinion so crucial, if I may? A couple of positive implications that I would like to share with you this afternoon, and these are in according to my personal opinion. Some may not agree with me, but this is what I believe, at least. First, I think foreign financial institutions may be more prone to enter into GMRA transactions with Armenian counterparts once they know that there is a legal opinion, and once they know that Armenian counterparts can actually enter into GMRA documented transactions. So foreign financial institutions may be more sort of encouraged to transact with Armenian financial institutions, which would subsequently mean more liquidity for Armenian financial markets, Armenian financial institutions. That will be a way to bring in more liquidity, which I think on part of the bank's clients and customers will, the customers of Armenian financial institutions will have better and more diversified options to transact with Armenian financial institutions. The fourth, this, I think, will enhance the relations of Armenian financial institutions with their foreign counterparts. So it will deepen the relations, and it may also open up new or alternative financial transactions with their foreign counterparts. So this may encourage various other transactions to be entered with foreign financial transactions, and this will give Armenian financial institutions more access to foreign, more developed, more robust financial markets. Now, concerning local transactions, I know that Armenian banks and other financial institutions, they do enter into repo transactions, but usually, if not all of them, are executed or entered into under local law and local traditions. So I would like to take this opportunity to encourage my colleagues. I know there are some people from dealing departments, financial departments of Armenian financial institutions present here today. So I would like to encourage Armenian financial institutions to enter into GMRA documented repo transactions when they're transacting between themselves, because when the transaction is GMRA documented, then it has a higher level of protection. And as previously mentioned in my previous slide, it may open up new opportunities to attract liquidity for their foreign counterparts. So who is covered under the legal opinion? First, the Central Bank of Armenia. So any transaction conducted or executed by the Central Bank of Armenia is covered under the legal opinion, as well as commercial banks, credit organizations, insurance companies, investment fund managers and investment funds, pension fund managers. I'd like to sort of pinpoint the pension funds because these are the most, I think, robust non-bank financial institutions or non-bank investment funds in Armenia rather, and companies as well. So non-financial companies can actually enter into GMRA documented repo transactions. I know that there are some transactions within the Armenian financial market where repo transactions are done with non-financial, so non-financial companies, and in this case, it can be done under GMRA. So the legal opinion covers all these institutions. Another important aspect that I'd like to pinpoint, that's the location of securities. So if you're wondering whether the securities which are subject of the GMRA repo should be in Armenia only, and the answer to this is no. Any securities, purchase securities, loan securities, margin securities, collateral or margin comprising of securities may be held outside of Armenia. So you may transact while the securities are not in Armenia, according to the legal opinion, which I think is important. One thing that I'd like to pinpoint, which was one of the issues, because before this opinion was prepared, I know that some foreign counterparts have been entering into some repo transactions with some Armenian financial institutions. And the question that always came up, and I've advised on some of those transactions in the past, and one of the questions that always came up was the recharacterization risk. That is, the questions that I got constantly asked was, would an Armenian court recharacterize a repo transaction as a collateral against a loan transaction? Okay. And maybe deem the transaction as non-compliant to the law and deem it null and void. So that was a constant question I was getting from my clients, and the recharacterization risk was evident, and we always brought this up in private legal opinions and private legal advice that we provided to our clients, because there was unclarity. But thanks to the efforts of the central bank and the National Assembly that passed the law back in 2020, I believe this risk is at least minimized, if not totally eliminated, because the authors of the law are very clear that the repo transaction is a distinct transaction as opposed to a loan and collateral transaction. So a repo transaction is basically when you sell and buy back the securities that were sold. So I wanted to specify this, the minimization or the absence, if I may, of these risks under Armenian law, and let me share with you that this risk was also eliminated, and the legal opinion talks about this as well. Another important aspect that always or usually came up when I was engaging with foreign financial institutions as the lawyer in Armenia was the question whether a foreign financial institution that enters into a transaction, into a repo transaction, or any other financial transaction, whether that particular foreign financial institution may be deemed as licensable under Armenian law. Should it apply for and receive a license from the Central Bank of Armenia? That was a constant question I was getting from my clients. And thankfully, while we were working on this legal opinion, the Central Bank came up with a very helpful official clarification. And as some of you or many of you may know, that official clarifications issued by the Central Bank are very important in Armenia at least, and they sort of direct the thinking of the regulator, and also I believe they're part of our local legislative and regulatory framework. So in February 2022, the board of the Central Bank came up with an official clarification that basically said the following: that licensing requirements shall not apply to services provided by foreign financial institutions in Armenia if the offer that they're making is not a publicly targeted to Armenian residents. So if it's a private kind of a transaction between two financial institutions, the first case. And the second case is that the offer or the transaction does not imply that the institution, the foreign financial institution, intends to gradually extend the offer to a wider circle and regularly provide services in Armenia. So basically, the Central Bank is saying if a foreign bank enters into a transaction with an Armenian counterpart, and it's a private transaction, and it's not publicly available, it's privately discussed, negotiated, executed, then the foreign financial institution, the foreign bank is good to go. Doesn't need an Armenian license. This is a very important sort of clarification, piece of regulation, because this question was always asked, and it was unclear until this clarification. Obviously, this latest piece of regulation is discussed in the legal opinion in detail, and of course the Central Bank. I'll also like to thank the Central Bank, take this opportunity to thank the Central Bank for improving our regulatory framework regarding this. I also want to mention the regulatory framework regarding the pension funds. I don't know if today the pension funds or the managers in Armenian pension funds, we have 3 pension funds we have three pension fund managers, 2 mandatory and 1 voluntary. I don't know if they're connected to this webinar, but it's important because pension funds play a vital role, and the fund managers play a vital role in Armenian financial system. So I wanted to pinpoint an important aspect of their transactions, repo transactions, and say that while the law, Armenian law, says that the assets of a pension fund may not be collateralized or pledged as a security for the liabilities of the fund, there is an exception under Armenian law where it says unless the transaction is a repo transaction. So if Armenian pension funds, both mandatory and voluntary pension funds, enter into a repo transaction, then the limitation, then that legal limitation would not apply to them. So they're good to go to enter into repo transactions. And I really hope that Armenian pension funds do enter into such transactions. So I would like to thank you for your presence and for your patience, for being here. This will conclude my part of the my speech, and I'll be available for questions. Thank you.
Okay, let's start with our Q&A sessions. We have 20 minutes to go. We'll start from those present in the hall who has questions here. Yeah, please.
First, thank you very much for this quite interesting presentation. I have two questions. The first one, we'll appreciate very much if you share with us this legal opinion. So in case if we have some partner to share with them consequently, that's a big part and important. And the question is, do we have a legal background for suing or disputing this type of cases here in Armenian court within the English law? So do we have any examples here in Armenia, or how realistic those are? And the second question is, what's the rationale to enter into the GMRA contract with our local partners? I mean, in case of local transactions. So I don't see any rationale to enter here, even if we don't know the exact results, or we don't know how to dispute this type of cases here in Armenia within English law. So this is a type of legal question. I'd like you to clarify this.
Sure. Thank you. These are important questions. So first, yes, the legal opinion will be shared. I think the central bank will share it with you, right?
Yes, with a disclaimer that they may not rely on their opinion.
Yes. So the legal opinion will be shared as on a non-reliance basis, but the central bank will take care of that. So they will send it to you. First, are there any cases in Armenia? Have there been any disputes in Armenia under English law? Not extensively, but the short answer is yes, not extensively though, and mainly involving Armenian, as far as I know, of course, I'm not familiar with all the cases, but as far as I know, there have been cases where Armenian resident companies have entered into a transaction, not a report, but other transactions with foreign counterparts, and some part of the dispute was held in Armenia. So yes, to some extent. Obviously, Armenian judges are not. There might be exceptions, of course, but usually they're more proficient in Armenian law. But there have been cases, as far as I know. Now, the rationale for entering, the second question, the rationale for entering into GMRA documented transactions, which are local transactions. Well, this is sort of my thinking. If I were working in a bank, this would be my thinking. It might not work for all financial institutions, but at least some of them may find it useful. First, you'll practice it. Obviously, GMRA documented repo transactions are significantly, as far as I know, the local transactions they significantly differ from local transactions. So you'll practice it. Your lawyers, your dealers, your financial experts, they'll familiarize themselves with GMRA documented transactions. That's the first. You'll create the infrastructure within your bank. The infrastructure, the skills, the knowledge. So once the opportunity comes to transact with a foreign counterpart, you know what is expected, what you're going to do, and the transaction with your foreign counterpart may be smoother, faster, more efficient. I know a case of another transaction in Armenia that took the parties almost 9 months to enter into, because I see Larissa here, who was working with me on that transaction, and it took them more than 9 months because they needed significant time to get into the unfamiliar documentation and familiar agreements, etc., and to set up the internal procedures and policies to enter into such transaction. So that's one rationale. Second, it provides more protection. It provides more protection both under Armenian law, because Armenian law cites the international financial transactions as acceptable to Armenian law and provides better protection for the parties. Okay. The third, if there are any potential disputes, I don't know if any repo transaction has gone to an Armenian judge or not. I don't think so. Never. Yes. As far as I know, that never happened, but I might be wrong. If there is a potential dispute, and usually, or in some cases, the transactions are quite large. If a dispute goes to a judge who is more proficient in a repo transaction under English law, a foreign judge, then that dispute may be more efficiently resolved compared to how it would have been resolved here in Armenia. So, thank you.
To add why we would need to have GMRA contracts between two local counterparties. It's very simple. Standardization always helps. So if we operate in one standard environment, it creates network effects, and it puts Armenian repo market on the international repo market map. That's it.
We'll now give the turn to those present online. We'll be taking turns, one participant for each location. So those online, please raise your hands if you have any questions, and I'll invite you. No questions on the online platform? Okay, questions here? Yeah, please, Levan.
Thanks again for the presentation. During just listening to this presentation, I just wondered if it will be more productive to have triparty repo for integrating GMRA more effectively, more productively in this market, and whether when you examined our legal sphere and the opportunities of GMRA, whether you consider the opportunity to have triparty agent in this market, and after having triparty agent, GMRA integration to the market will be more productive for the market, or there is no sensitivity?
Well, I'm a humble lawyer. I cannot assess how productive it would be. So, what's your guess? You're way more experienced than me.
No, I know that we in the market in other countries, in other markets, it's more easier to integrate the standardized agreement to the market when you have an agent, which in a mediation of which the contract are signed, and the contract is the same for all participants. So there is no two companies or two banks that can have agreement via WhatsApp, just typing that I'm agree, okay, let's do it.
So yeah, as I said, you have more experience in this, but I remember back in 2000, early 2000s, actually, the central bank, I was working for the central bank then, introduced the legal team together with the financial transactions team. I think Garagin was working for that department at that time, no? Anyway, so the central bank introduced standardized repo master agreements for all banks. And that was the standard then. The banks, they just had to negotiate, you know, the terms of the terms, not the agreement, but the terms of the transaction itself. And that significantly improved the volume and the quality and the quantity of those transactions. So generally, I would agree with you. Yes.
We have a question from the online participants. Richard Komoto, please.
Hello. I wonder if I can just comment on that question about triparty repo. But first to say that I'm very pleased to say that I was involved in some training on GMRA in the early days, and it's great to see this project come to fruition. In fact, as far as Triparty is concerned, contracts are not necessarily standardized. The fact that there is Triparty management is only affects the post-trade, doesn't affect the repo at all. And the problem, I think, with Triparty is it is largely a dealer to customer transaction, and so you need a market in that before it really becomes worthwhile. I think perhaps there are two issues here, and Triparty deals with collateral management rather than any legal issues or transactional issues.
Thank you, Richard. Any other questions here? Last call for questions from the online participants. And we will wrap up now. Thank you so much for attending and participating. Like Varoujan mentioned, I'll share the opinion with the banks later. And yeah.
But not only the banks, right? So pension funds and other funds, those who enter into repo transactions, or you're going to share it with only with banks?
Well, we've discussed with banks, but we can discuss the other options as well.
Yeah.
The more, the better for us, actually.
Yeah, I think we should share with all the market participants.
Okay.
And everybody, let's thank Varoujan Avedikian for deep insights.
Thank you. Thank you. Thank you. Thank you so much, everyone.